This is the fifth in a series of short videos that will provide information about the Family Homes on Reserves and Matrimonial Interests or Rights Act, or the Act. We will look at the methodology provided in the Provisional Federal Rules for dividing the value of matrimonial real property in the event of a relationship breakdown or the death of a spouse or common law partner.
When a conjugal relationship breaks down, both partners are entitled on application made under Section 30 to half the value of the interest or right held by at least one of them in or to the family home on the reserve. A spouse or common law partner, whether or not they are a member or an Indian, may also be entitled to share in the value of other structures they may hold on the reserve that were acquired during the relationship. However, only spouses or common law partners that are members of the First Nation are entitled to a share of the value of the land. Non-members can never take possession of the land nor share in its value. The value of the interests or rights is based on what a buyer would reasonably be expected to pay a seller for comparable interests or rights. There are other considerations that determine these valuations. As it is a fairly complex process, it's recommended that parties get legal advice to guide them through it. Applications for division of value must be made within 3 years of the date of separation. The Provisional Federal Rules in the Act do not apply to the value of the lands that have been allotted according to custom, as these allotments are not recognized as legal holdings by the federal government. However, they will apply to structures on custom allotments, which are recognized by First Nations or by the courts. Under Section 36 of the Act, a surviving spouse or common law partner may choose to make an application to receive half the value of the deceased spouse's or common law partner's interest or right in the family home, and of other matrimonial interests or rights, rather than inherit under the will, or if there is no will, under the intestacy provisions contained in Section 48 of the Indian Act. Upon hearing the application, if the court determines that the surviving spouse or common law partner is entitled to an amount, the survivor will not be able to benefit from the deceased's will, or if there is no will, from the provisions of the Indian Act in respect of the same interest or right. In other words, the surviving spouse or common law partner will have to choose between receiving an amount under this Act or an amount or right under the will or the Indian Act. Administrators and executors of estates will have access to information regarding the options for survivors that may affect the estate administration. The surviving spouse or common law partner has 10 months from the date of the death of their spouse or common law partner to make application to have the court determine their entitlement under Sections 34 and 35 of the Act. This requires the survivor and the executor or estate administrator to determine which option the survivor wishes to pursue.
For further information, please visit our website at COEMRP.ca. This video is for information only and should not be relied upon as legal advice. Individuals should always obtain legal advice from a lawyer familiar with their specific circumstances and the provisions of this Act.